we are going to learn the legal system of the world. We have different categories of the law. First of all, we are going to see whether the civil law was. The civil law was a major branch of law in the legal system. It deals with a behavior that constitutes an injury to an individual or other private parties, such as corporation. Whether we have different classification of civil law, the contract law, property law, family relation, the civil wrongs causing physical injury or injury to prosperity, what we call torts. The purpose of civil law is to protect the right of individual by allowing a person whose right who infringed to seek or legal remedy, often in form of monetary compensation, in order to restore them to, as a close to the position they were in prior to the wrongdoing. We have difference. The difference between common law and civil law. In terms of civil law, the judges often describe as investigation, establishing facts through witness examination, and whether applying remedies found in legal courts. In civil law, the lawyers represent the interest of their clients in civil proceeding, where the lawyer have a central role. There is what we call common law. The difference between civil law and common law, this is in common law, the lawyer make presentation to the judges, sometimes the jury. He examines the witness themselves. The proceedings are then referred by a judge. In terms of definition, the common law is a body of unwritten law based on legal precedents established by courts. It influences the decision-making process in unusual cases where the outcome can't be determined based on existing statutes, written rules of law. There is what we call the other names of common law. We may call it case law, non-statutory law, procedural, statute law, or sonor and termot. The third classification of law as a real-world classification system. We may call it religious law and Shalia law. The religious law includes ethical and moral codes taught by religious tradition. For example, we have the examples. We may mention it, the exemplary of religious in terms of legal codes: the Jewish Halakha, the Christian canon law, and Islamic Sharia. All the above mentioned is a wider theological conception in church, but in modern time distinct from secular state law and Hindu law. The establishment of religious and religious institution, the Baha faith, the Buddhism, the Christianity is divided into two main parts: the biblical or Mosaic law and the canon law. The Hinduism, Islam's, Jainism, Judaism, all are facilitated to explain the religious law and to explain the law include to Sharia and the Bible where are included. That's why all government should reinforce the capability of Sharia and the capability of Bible where are spread. The state religion is a religious body officially endorsed by the state, while the theocracy is a form of government in which God or deity is recognized as a supreme civil ruler. In both theocracy and some religious jurisdiction, there is what we call conspicuous objectors may cause religious offense, the contrary legal system, a secular state, or matricular societies in which government doesn't formally adopted in particular religion. We have the obligatory for Baha laws as we have been mentioned the above. The obligatory prayers each day. The 19 days fast from the sun rises to the sunset. The gospel and the backbiting is prohibited. In terms of Christianity, the Mosaic Law is considered as an Old Testament, while also is called Divine Laws, Biblical Law. The most famous example being the Ten Commandments. And another is the instruction of Jesus of Nazareth to his discourse in the Gospel, often referred as the law of Christ, or the new commandment, or the new covenant in contrast to the old covenant. The apostolic decree of Act 15 is still observed by the Greek Orthodox churches, while the canon law, the Catholics, Anglicans, and Orthodox churches. In some Christian denomination, law is often contrasted with grace, the law and the gospel, and the earthiness of the law. The contrast here speaks to the attempt to gain salvation by obedience to a code of law, as opposed to seeking salvation through faith in the atonement made by Jesus on the cross. The main reason you have been talked about is the classification of law accordingly to the legal system around the world. We have different law, but we are going to learn the canon law. The canon law is the body of laws and regulation made by or adopted by the ecclesiastical authority for the governance of the Christian organization and its members. We have different categories of canon law of the Catholic Church: the Oriental law, the liturgical law, sacramental law, and matrimonial law. The canon law was categorized into several main parts: the Oriental law, liturgical law, sacramental law, and matrimonial law in terms of marriage. The particular churches, the canonical law structure has been justified. There is what we call jurisprudence, temporal goods or property, laws of person, canonical document, and penal law. The fourth categories of the law, that is what we call pluralistic law. The pluralistic law is what we call when the situations of the legal coexistence in a single society failed. Initially described in colonial situation in which colonial power superimposed an European legal system over an existing indigenous system. The legal pluralism is known as and understood as a fundamental characteristics of a legal system. There is what we call the pluralism. And the pluralism refers to the way a society and the system of the government or organization that has been different groups that keeps their identities while existing with other groups or more dominant groups. What is going on? The question is, when you have been define the terms pluralism, we have just questioned myself that who is the father of pluralism? Who governed? This is the purpose of the law of pluralistic government. The father of pluralistic government, pluralism, is called Robert A. Dahl, who wrote the seminal pluralistic works. Who governed the governor of this pluralism is David Truman and Seymour Martin Ripset. We're going to mention at least 4: purpose, function, and characteristics of good law. The good law may have 4 purposes. As you understand and as you see in different government orders, we may have it may characterized by 4 purposes and 4 objectives. The one is to maintain the order of the government, establishing the standard where the government should follow, and resolving the disputes. The 4th one is to protect the individual rights and liberties. After the concerns of the main purpose of the law in terms of good law, we have different function of the law in good government or in where the democracy is there. Law are to keep the peace in the country, shaping normal standards. It promotes the social justices. It facilitates the orderly changes, providing a basis for compromises, and lastly, is to help in facilitating a plan of government. In Rwanda, we have NST1, National Strategic Action Plan of 7 years, but now we have NST2, National Strategic GCOFs, 5 years. We have different characteristics of effective law. The effective law should concerns whether are known in the public and acceptable in the community, and be able to enforce, stable, and be changed, able to resolve disputes. And we are going to learn what is the difference. What is the difference public law and private law? The public law should focus on the set of the norms, while the private law is concerned to economic elements. The public law was concerned to the public sectors, while the private law should concern the private sectors. The public laws should concern the focus of the authorities permitted, while the private law should focus on the society permitted. The private law should concern of civil wrongs, while the public law should concern the authority are limited. To where civil wrongs are, to where the authority is or are limited. The public law should concern to the relationship between the governed and the governors, while in the public law, the governor's right and the responsibility are concerned. That's why all governments should concern to the rule of law, to where the influence of the authority of the law within the society focused on the behavior, even the behavior of the government officials. That's why every citizen is subjected to the law. We are here and we are going to do so as is mentioned or are mentioned. All laws are concerned to the codes of Hummurabi, where is written and where is formal legal in all of where legal system, where the collection of law about 282 laws are inscripted on and upright stone pillars containing many fundamental legal concepts we will recognize in today's legal system in the world. We will continue where we will learn different principles of the law and function. Or I may mentioning it, the first principle of law is to establish the standard. I have mentioned in it. The second one is to maintain the orders, protecting rivalries, resolving dispute where the disputes are unavailable in society, where the subjective law is a set of application of objective principles onto specific situations. Example, everyone who has a right of free speech, but which is an objective right. Objective law is the groundwork of subjective law. It intended to be the foundation of law. It contains all fundamental principles that guides written and unwritten law. Those are unlimited. They run further express different elements of law. Where the first where learn further mentioning it, the law must exist and shall be obeyed by all. The second one, the law must be published. The third one, the law must be prospective in nature, where the effect of the law only takes place after the law have been passed or published. The fourth one is where the law should be written with the reasonable clarity to avoid an unfair enforcement. The fifth one is where the law must avoid contradiction, where the contradiction must be avoided. The sixth one, the law must not command the impossible, where the impossibility should not be commanded. The seventh ones, where the law must stay constant over time. The law must be constant. The eighth ones, the officials' action should be consistent with the published law. We have different elements of state where the population are and the territory and the government. I may thank you for you making subscribe, like, share, and comment. And afterwards, we may run different things according to the law and introductory of the dictatorial government around the world. Thank you very much.